Hello everyone, thank you for listening to this knowledge clip. My name is Stalenhoef and I'm a master student at Utrecht University in the Legal Research Master Program. In the coming 25 minutes I will tell you more about dual-use export controls and its impact on higher education. More specifically, we will touch upon the context of dual-use export controls, the newest regulation that entered into force a month ago, and the impact of this newest regulation for universities and academics. Hopefully this video will be instructive to you. Before starting with the actual content of this knowledge clip, I would like to set the scene. The context of the recently enhanced regulation is shaped by the EU's global strategy and more in particular strategic autonomy as its policy objective. For universities, this puts the principle of openness in international cooperation in a different context and perspective. This is as such also formulated in the communication on the global approach to research and innovation. Rising geopolitical tensions challenge human rights and fundamental values such as academic freedom. At the same time, the European Union is expected to level the playing field, promote reciprocity, protect intellectual property rights, mitigate risk, and to ensure security. So before we go into depth, it's important that everyone is on the same page. Therefore, I will first provide you with some background information. It is important to note that the European Union can adopt regulations based on different competencies. The strongest competency is exclusive competence. Based on this, the European Union is able to legislate and adopt binding acts. The second strongest competency is the shared competence. This means that the European Union and the member states are able to legislate and adopt legally binding acts together. The third variation is the supporting competency of the European Union, which entails that the EU can only intervene to support, coordinate or complement the actions of the member states. For this topic, it is important for you to know that the regulation concerning dual-use export controls we are going to talk about is adopted based on exclusive competence of the European Union, because it is adopted with the aim of regulating the common commercial policy of the European Union. The regulation of export controls of dual-use items is adopted by the European Commission and Parliament, so they have drafted the text of the regulation. However, the national member states exercise the specific controls with their national authorities. This is the same for granting licenses. This is done by the national authorities as well, often by customs services. What may be required from research organizations, they have to comply with the regulation. Although this regulation is adopted on the basis of exclusive competence, it also affects areas in which the EU only has supporting and shared competence, namely research and education. For research, the EU has shared competence, and for education only supporting competence. However, according to the European Commission, the academic world still has to comply with the regulation, although the regulation might impact research and education. In the draft guidelines for research involving dual-use items, the Commission stated that academic freedom is a fundamental right guaranteed by the Charter. However, it is not exempting researchers and research organizations from complying with regulations that are established to safeguard the security interests of the EU and of its member states. According to the European Commission, research disciplines within science, technology and engineering are more likely to be affected by the regulation on dual-use export controls because of the research topics within these disciplines. These research topics involve more often dual-use items than, for example, research activities within humanities, social sciences and economics. Academic freedom is protected under Article 13 of the Charter. The question arises whether this regulation impacts or might infringe academic freedom. Other questions that arise are whether it is appropriate to let universities and academics have all these obligations under the new regulation. And how will the regulation specifically impact universities and academics' mission, core values, rights and obligations? And might liability be involved in case of non-compliance with the regulation? The outline for the coming 20 minutes will be as following. I will start with an introduction to a recently adopted regulation by the European Parliament on export control. In part 1 of this knowledge clip, I will elaborate on the context and basics of export control, and I will address how export controls at all affect universities and academics. In part 2 of this knowledge clip, I will elaborate on the specific consequences of the newly adopted regulation for universities and academics, and I will more specifically focus on the consequences of non-compliance for universities and academics. I will conclude this knowledge clip with some points for discussions or further thought. Moving on to part 1 of this knowledge clip. But before diving into detail on the recently adopted regulation, I would first like to address some basic concepts so that we are all on the same page. Therefore, I will address what dual-use items actually are, who qualifies as an exporter of dual-use items, and when are dual-use items actually exported. So the main question, when do export controls apply? So what are dual-use items? Dual-use items are items that can both be used for civilian and military purposes. And the word item here should be understood in a broad sense. An item does not necessarily have to be a physical item. Technology and software also qualify as an item in the term dual-use items. Some examples of dual-use items are, for example, nuclear technology, chemical and biological tools, night vision technology, some models of drones, or for example, ball bearings. Moving on to the second aspect that is crucial for a good understanding of export controls on dual-use items. This is the term export and exporter. An exporter of dual-use items can be both a natural or a legal person. So it could be your neighbor or the company in one of the biggest cities. And as export qualifies exporting a dual-use item outside the territory of the EU, that would qualify as physical export, but also the transmission of software or technology by electronic media, also including telephone communication or emailing with someone outside the territory of the European Union. A third variation of export is that oral transmission of technology also qualifies as export. So it is important here to emphasize the broad meaning of the term export. So when emailing someone in Pakistan, for example, on a certain software which entails details about a dual-use technology, that also qualifies as export. Same as phoning someone from China and discussing certain research on dual-use technology. Hopefully you now have a grip on what dual-use items are and what qualifies as export. So the regulation of 2021/821 applies when a natural or legal person is planning to export a dual-use item. The consequence of this is that if this is the case, an exporter has to apply for a license to export the dual-use item. To make this a bit more concrete, I will give you an example. So, in case a European company that is involved with 3D printing and does research on the newest techniques to make the printing even more realistic, it wants to partner up with a company outside the territory of the EU to create energetic materials for their newest technology. In such a case, the exporter is the company based in the EU. The dual-use item is the technology related to 3D printing that can both be used for civilian and military purposes. And the export is the fact that the company wants to collaborate with a company outside the territory of the EU. In this case, we will assume that partnering up means sharing details about the research. This means that the regulation would apply and that the company within the European Union should opt for a license. Now that you have an idea of what dual-use items are and what exporting of these items is, I will give you a bit of an introduction on the context of dual-use export controls. Because the fact that we regulate export controls on dual-use items is not very new actually. We already started regulating dual-use items in the European Union from upon 1994. Which eventually resulted in a regulation of 2009, which was still into force up until a month ago, just before the new regulation of 2021 entered into force last September, only a month ago. Regarding the regulation of 2009, there was some kind of unease and dissatisfaction because people were afraid that the regulation could not keep up with today's evolving and new security risk, rapid technological and scientific developments, as well as transformation in trade and economic process. So from 2013 onwards, a review procedure was initiated to examine how export controls could be better regulated. What is very remarkable was that for the first time in the theme of export controls, human rights considerations were taken into account in the design of the new regulation. How specifically, we will come back later to that. So, now the question arises, how does this newly adopted regulation affect universities and academics? Well, the European Parliament specifically states that research and elaborating research ideas and communicating details about dual-use technology also qualifies as export. So therefore, universities and academics are also subject to the regulation and have to apply for a license to export dual-use items in case they want to export an item outside the territory of the European Union. Currently, the European Commission has published draft guidelines for universities and academics on how to interpret the regulation in light of research and education. And last month, the European Commission released recommendations for the academic sector. But as I stated before, the European Commission really highlights that although academic freedom is a fundamental right, it does not exempt researchers or research organizations from complying with the regulation. So, universities and academics are subject to the regulation in case they aim to export a certain good, software or technology that qualifies as dual use outside the territory of the EU. Keep in mind here that there is a broad meaning of both the term item and of export. So research output, but also sending a prototype or giving a presentation outside the EU territory on dual use technology and even publishing a paper on dual use technology qualifies as export, which means that you need an export license. The regulation excludes two situations from being subject to the regulation, namely when the item can be qualified as basic scientific research and when it is available to the public domain. However, a lot of new, high-tech and cutting-edge technology can of course not be qualified as basic scientific research that is available to the public domain. The European Commission itself states in their draft guidelines that even teaching might be subject to the regulation. Imagine, for example, teaching in a foreign country outside the territory of the European Union. This is also a way of exporting knowledge, of course. However, it is more often the case that teaching does concern basic scientific research that is available in the public domain. So therefore, the exceptions more often apply to teaching than they apply, for example, doing research into the newest technology. To make this all a bit more concrete, I will give you an example that I will use for the coming minutes in this knowledge clip to illustrate practical consequences and impact of Regulation 2021/821 on universities and academics. Imagine a researcher from a European university that is doing research into underwater fishing system with the aim of establishing a system that can identify possible new species underwater. This researcher reaches out to a researcher from a non-European university who is also active in the field. This cooperation begins with an exchange of views on this research topic and eventually leads to the fact that both parties want to take this research up further together and doing joint research into underwater fishing systems. For this researcher, European researcher wants to send a prototype of a certain underwater fishing system to the researcher from the non-European member state. In addition, researcher from the European member state wants to send a concept paper that is going to be published in 3 months that she has been writing on this topic to the researcher from a non-EU country. The researcher from the European country has not yet reached out to the department dean of her university to discuss the matter. Now the question rises, how does the regulation apply to this hypothetical case? In the coming minutes, I will explain the regulation by highlighting certain aspects of the regulation and applying this to this hypothetical case. So, as you can see here, there are several triggers for export controls on the under the regulation. And it might also be good to highlight here, as you can see under bullet point 4, that the European Commission itself also highlights that, for example, publishing a paper on listed dual-use technology is also triggering export controls. So this is not only an interpretation of the regulation by me or just a guess, but it is specifically stated by the European Commission itself as well that publishing listed dual-use technology requires an export license. Connecting this to the hypothetical case, it is clear that the European researchers should conduct an initial risk assessment to consider whether and to what extent export controls on dual-use technology or items apply. Additionally, the researcher should reach out to her supervisor or the dean of the university to mention that she might be involved in research that involves dual-use items. For this initial risk assessment, the researcher will examine whether the underwater fishing system is a dual-use item and whether she is planning to export this item. Looking at the export triggers listed in this section, 3 export triggers can be identified. The fact that the researcher wants to send a prototype of an underwater fishing system can be qualified as an export. In addition, the researcher wants to share a draft paper that is about to be published that concerns technology that is used for the underwater fishing system. Since this publication has information on a specific dual-use technology, this export is also subject to export control. The fact that the researcher wants to collaborate at all with a non-European researcher from a state outside the EU on dual-use items is already subject to export control. Consequently, the regulation of 2021 applies to the hypothetical case, and the researcher should opt for a license to export the dual-use items, and she should comply with the provisions of the regulation. So, coming to the next aspect of the regulation has some catch-all clauses related to the term items. The regulation has listed some items that can immediately be qualified as dual-use. These items are listed in Annex 1. You can see this on the left side of the slide. But the regulation does not list all potential dual-use items. Therefore, the regulation also has included some catch-all clauses. This means that it might be the case that a non-listed cyber surveillance item requires an export authorization. This might be the case if the item is connected to internal repression or the commission of serious violations of human rights and humanitarian law. It is too much to enter into detail here, but the regulation also describes some other situations that are covered by the catch-all clauses. It is very important to emphasize here that this impacts universities and academics to a great extent, because practically this means that universities and academics have to investigate whether the non-listed dual-use items might be or will be used in connection to sensitive end uses specified under this regulation. So connecting this to our hypothetical case, the European researcher should examine whether the technology for underwater fishing systems is listed in Annex 1 or whether one of the catch-all clauses applies. In case the technology is listed in Annex 1, the researcher does not have to take the catch-all clause into account. In case the technology is not listed in Annex 1, the researcher should look at the catch-all clauses of Article 4, 5, 8 and 9 of the regulation. In case one of the situations described in these catch-all clauses applies, the dual-use item of the European researcher is subject to export control, and the researcher should opt for an export control license. So, another aspect of the regulation is the internal compliance program. The regulation highlights that it is very important that beside the initial risk assessment, the exporter creates an internal compliance program. According to the regulation, the internal compliance program is also connected to a so-called due diligence. And as you can see on the slide, the ICP depends on the particular size and organizational structure of exporters. So that has to be taken into account when developing and implementing an ICP. The European Commission does give some information on what an ICP for universities and academics should look like in their recommendations. In addition, they highlight that it might be a process that takes time and effort, and I quote here, "In research environments, setting up compliance measures to conform to export control laws and regulation is a process that takes time and effort." Well, it certainly does, because an ICP should include some words on how the top level of the organization is committed to the compliance and how this commitment is communicated through the organization. In addition, the ICP should include some words on how dual-use export controls are handled within the organization and what is reasonable for the obligations following from the regulation. The ICP should also include a plan on how trainings are organized to increase awareness within the organization on dual-use export controls. The ICP should also include a plan on how performances related to dual-use export controls are reviewed, but also a plan on how records are kept, and also a plan on how physical and information security is secured. So connecting this to our hypothetical case, the European researcher has to take the internal compliance program of her university into account when exporting a dual-use item. Of course, it is important that the university has such an internal compliance program. How advanced and professional this program has to be will depend on the size and activities of the university. If the university is dealing with export of dual-use items more often, then it is expected that the university has a more professional program than when this is the first time the university is confronted with the export of dual-use items. Assuming that the university has implemented ICP, the ICP should start with a risk assessment to determine the specific dual-use trade risk connected to the specific activities the researcher aims to do with the dual-use item. The risk assessment has to identify vulnerabilities and risks connected to the export of the item and should be conducted before the start of the research, but also during and after the research. The dual-use item that the European researcher aims to export should be identified, and a transaction risk assessment should be performed, including the checks on trade-related embargoes, sanctioned or sensitive destinations and entities, end-use and involved party screening and diversion risk screening. The ICP of the university should also address the points mentioned on the slide here. So we come to an interim conclusion now. We have seen the impact of catch-all clauses, the fact that universities and academics should conduct an initial risk assessment to create an overview of the potential dual-use related research projects, and we have seen the impact of an internal compliance program and how universities should adopt such a program. We have arrived at the second part of this presentation. What are the current consequences for universities and academics of the regulation of 2021 on dual-use export controls? As said before, the regulation is adopted in May 2021 and entered into force last month, September 2021. This means that universities and academics should live up to the regulation and comply with it. As said before, this entails doing an initial risk assessment and, for example, drafting an internal compliance program. However, there are still a lot of uncertainty surrounding the specific obligations for universities and academics. In an attempt to remove a bit of this uncertainty, the European Commission has released a recommendation document 2 weeks ago, giving some guidelines on how to interpret all the obligations following from the regulation. In addition, the European Commission released draft guidelines for research related to dual-use items in 2019. However, both the recommendations and the draft guidelines have no legal binding power. Therefore, it's not binding and it can only function as a guideline or, just to give a hint on how to interpret the regulation. So, what happens in case a university or an academic does not comply with the regulation? Non-compliance could take different forms. One could think of a situation in which a university or an academic exports a dual-use item without a license or does not carefully implement an internal compliance program. Although the regulation imposes obligations on exporters, it does not prescribe what sanctions are needed or appropriate in case of non-compliance with the obligations. Consequently, how compliance is enforced and controlled is determined by each member state and therefore differs from one member state to another. Each member state, under its own competences, issues national export control laws and policies to complement Regulation 2021. These national laws focus on the specifics concerning the licensing system, penalties, and other regulatory procedures. Although there is no specific case law available that focuses on the consequences of non-compliance with export controls law by universities or academics, some remarks can be made on the possible consequences of non-compliance for universities and academics. For example, in the Netherlands, non-compliance with the regulation could be a criminal act under the Strategic Services Act or the Economic Offences Act. However, to be criminally liable, intent is necessary when it comes to non-compliance with export controls. So, if a university or an academic takes sufficient precautions and takes appropriate actions when exporting a dual-use item, criminal prosecution will probably not be the case in the event of a small error in the compliance with the regulation. However, in case a university or an academic deliberately not complies with export controls, criminal liability might be lurking. Despite the fact that criminal law is the primary enforcement mechanism of Regulation 2021, private law could also play a role in this respect. Tort liability could be lurking when damage is caused by not complying with Regulation 2021. The European Court of Justice recognized in 2002 the enforcement function of tort liability in enforcing EU law. Two options are conceivable when a university or an academic does not comply with the regulation and damages result from this. First of all, it would be possible to hold a university or an academic liable on the basis of a violation of written law, based on the Dutch Code Civil. A second option is conceivable where the state is liable for failing to ensure the supervision and enforcement of the regulation, or a failure to oblige to the positive obligation to ensure the protection of a human right. Since it is too much detail for this knowledge clip, I will not further elaborate on this. So, we are coming towards the end of this knowledge clip, but first of all, I want to make some concluding remarks. It is important to emphasize that universities and academics must be aware of the consequences of export controls for their practice. The regulation has entered into force and there are serious consequences if universities and academics do not comply with it. Consequently, universities and academics should conduct an initial risk assessment and adopt an internal compliance program. However, looking ahead, there is still a lot of uncertainty and there are some difficulties. Please remember the tensions I highlighted at the beginning of this presentation. On the one hand, we want to protect academic freedom and enjoy it, and on the other hand, we also have to protect national and international security. It is the question what the responses of the universities and member states will be on this regulation. The obligations the regulations are posing are impacting the practice of universities and academics to a great extent. Hopefully, this will give you any room for discussion or further thought. Thank you for listening to this knowledge clip. If you have any further questions or want to discuss something with me, please do not hesitate to contact me. Thank you.